The next matter to come before the court, scheduled for 11:30, is Dillard versus Automation Tool and Die. Are all the parties to this case here?
Yeah, we are here.
Yes, Your Honor.
Thank you. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you let me know of your desire in that regard, I'm keeping the clock this morning and keep you apprised of the impending rebuttal time. The court's read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court, I'm David Meyerson. I represent Mr. Dillard in this matter. I'd like to reserve the 5 minutes for rebuttal. Thank you. This case is actually a Court of Appeals case of first impression. There is no Court of Appeals decision or Supreme Court decision on the issues that are presented in this appeal. The issue is whether or not the revised 4123.512 by Senate Bill 7 is constitutional or not as it relates to the restriction on the claimant's ability to 41A the complaint in an employer's appeal. The history behind the statute is that historically claimants have been afforded the right to 41A employer's appeals. Decisions from the Ohio Supreme Court in a number of cases, Robinson, Kaiser, Fowey, all recognized that the claimant has the burden of proof. The claimant is the one that has to reprove his case all over again in a trial de novo, and that there is no reason why 41A wouldn't apply to a claimant in an employer's appeal. Because of those decisions, the employer community went to the state legislature and got the state legislature to amend 4123.512 to add a clause that stated that on an employer's appeal only, the claimant could not dismiss that appeal without the consent of the employer. And that is what has led us to this point. I seem to be the attorney that is fighting this cause. I have a case from Cuyahoga County that Judge McClellan, I filed as some additional authority in this case, that Judge McClellan in Cuyahoga County has made what is the initial ruling in the state in any court on the issue of the constitutionality of this clause. We believe that the clause is unconstitutional on 3 bases. The first basis is the separation of powers. The Ohio legislature has, in fact, in this particular case, drafted a new civil rule for workers' comp appeals where the employer initiated the appeal. And because that conflicts with the Ohio civil rules, and the Supreme Court of Ohio is the one who creates civil rules, that violates the separation of powers. The second issue is the issue of equal protection. In this particular case, there is no rational basis why an employer appeal should be treated differently than a claimant's appeal. In fact, in this case, in Dillard's case, Dillard himself appealed some disallowed conditions. And in that case, Dillard filed a 41A without objection from the employer. But merely because the employer objected, because the employer did a notice of appeal on some other allowed conditions, can now Mr. Dillard somehow not be allowed to 41A that case. There's no rational basis to create a difference. You create a difference between claimants that filed their appeals and claimants who are in trial court because it's an employer's appeal. It makes no difference in the ultimate outcome of the matter. And in fact, the courts in Kaiser and in Robinson and in Fowey and with Arth Brass, these decisions all indicate that the employer is not harmed by the delay when a case is 41A, because the statute 4123.512 explicitly states that the employer's risk will be either changed or altered because of the final outcome or reimbursement if they're a self-insured employer.
Well,
Okay.
and that assumes you're a large enough employer that you can continue to maintain everything during 4 or 5 years that may be on appeal.
But Arth Brass specifically states that their risk cannot be charged for anything that is for the conditions in court until a final adjudication on the merits. And so this employer, Automation, cannot be charged for anything that the claimant has received for the allowed conditions that are on appeal in court, okay, until the final adjudication on the merits. So they're not being charged now under Arth Brass, or shouldn't be being charged now under Arth Brass for the allowed conditions in this claim.
Well, they're alleging that they lost some benefit.
Well, they're alleging that somehow they are no longer in a group.
That's what I'm saying.
But the group is not the Bureau, okay? The group is an entity outside of the Bureau.
Does that mean that the premiums and other related issues are different?
The premiums are, what happens in a group is a side issue, but a group is a TPA, third-party administrator, sets up a
Well,
group
you're
of
saying there's
employees.
no harm, they can just sit this out, and I'm seeking to understand.
Well, and then they can seek reimbursement and
Well, I think that goes
re-adjudication.
back to Judge Carr's question. There are many small employers and might not be able to tolerate that.
Right, but their risk in this case is not harmed by the issues that are in court. Their risk in this case might be harmed because it's an allowed claim, and this claim is already affecting their risk for the allowed conditions in this case that aren't up on appeal. Okay, that's two different things. And so that's a different thing. And this employer knows that they can seek reimbursement and recoupment of those dollars once this case is over with if they have been charged. In fact, this employer has done that in other matters. And so there is no harm ultimately to this employer because financially they will be reinstated as if we lose. That's assuming that the conditions aren't approved at trial. And remember, the conditions were granted administratively.
Was this constitutional argument made at the trial court level?
Yes. I made the constitutional argument in my brief in opposition to their motion to strike. And I set forth the 3 constitutional provisions that I felt that the statute violated in that brief, although briefly I did so. And I also restated that in open court as well. And so those issues were preserved at the trial court level. So in the equal protection argument issue, since there is no rational basis for this, and since the courts in Robinson and in Kaiser, these courts have already looked at these issues about whether or not there's harm to an employer during a 41A, and they determined that there was not because of 4123.512H. And then, as well, we believe that the statute is unconstitutional because of due process concerns. The ability to 41A case allows a claimant to ensure that his case is ripe for trial, he has all the evidence that he needs, medical experts have been deposed, witnesses have been examined or are available. There are many reasons why a claimant may 41A a case, whether or not he's available or some witnesses are available, whether or not the attorney's available. There could be lots of reasons for a 41A. And by forcing a claimant to try a case when it is not ripe in the claimant's position, then that creates issues of due process, where he does not have his day in court. And I think that Judge McClelland, in his opinion, eloquently outlays those concerns and indicates, why it is that this statute violates due process. The other thing is that, and going back a little bit to the issues about harm is that and this is part of the due process issue as well, The issues administratively about whether or not the claimant receives benefits or compensation while the issue's up on appeal, those issues are contested. And the employer has the ability to contest those issues. So if the claimant is seeking treatment and the employer wants to contest that, the employer can contest that administratively and has the right to go to a hearing in front of a district hearing officer and then a staff hearing officer. And if the industrial commission accepts jurisdiction, heard at the industrial commission level as well. So the employer has a right to contest the benefits even while this case is pending in the trial court. And employers do that routinely.
You're reaching in, well, you'll be soon at your rebuttal time, but I have a question.
Sure.
With respect to a dismissal without prejudice, is that a final appealable order?
Yes, because otherwise we would not be able to adjudicate this issue. If it wasn't a final appealable order and I had to try the case and then come before you and argue these issues, it would be moot because I could never go back and still have a 41A.
But is that actually the other side's argument?
No, that's my argument. Their argument is that by arguing it to you afterwards, somehow I still have a right. I don't have a right. I lose the right to have a 41A if the case goes to trial. That's the whole idea of a 41A, is not to go to trial.
Well, I'm confused. I had the same question as Judge Hensel because I get very confused in reading the Thornton case from the Ohio Supreme Court when it says that Thornton could dismiss the appeal without prejudice under 41A, and then because of dismissal pursuant to 41A, 1A does not typically operate adjudication on the merits, it's not a final appealable order.
But there's a whole series of cases
I
cited in
understand
brief
that.
that indicate a 41A
I've been involved in a lot of
right,
it, unfortunately,
right.
unfortunately, how are we going to look at it?
And this court indicated in Dillard 1 that a 41A1A is different than a 41A2, which
Well, it just said
which was-
it's different, it didn't say.
Well, but also
I think
indicated-
you kind of took a little liberty.
well, I think that the interpretation is that the 41A acts as an adjudication on its merits because and as an appealable order because it effectively eliminates, if it's not appealable, then there is no way to appeal that issue because the issue is gone because the trial has already occurred. And if the trial already occurred, then there is never going to be a 41A. And so you can't argue the constitutionality for that case.
And you have just about 3.5 minutes remaining. You may proceed to reserve as you wish.
Yeah, I'm going to reserve the rest of the time for rebuttal. Thank you very much.
Maybe you won't get attacked as much on the rebuttal.
Good morning, Your Honors. May it please the Court, my name is Michael Lewis. I represent the FLE Employer Automation Tool and Die. We find ourselves here yet again on the second appeal of a non-final order filed by the plaintiff. This has ultimately resulted in considerable delay in the trial of this matter, a matter which was originally prepared and ready to go forward at trial back in April of 2012. The appeal before this court is not from a final order, wherefore Automation asks that you grant its motion to dismiss for all the grounds cited therein. We would also point out, as I believe the justices have already noted, that the issues here may be waived. They were not sufficiently reserved or preserved by the one sentence at the end of the brief in opposition.
I was going to say, how do you sufficiently?
You have to make some material argument, explain how there is a constitutional violation. It doesn't have to be much, especially with a constitutional violation. And a court may, at its discretion, take the issue up sua sponte. And Automation is well aware of this. Plaintiff here argued that he not only argued it briefly in the one sentence at the end of his brief in opposition, but that it was also stated in open court. However, there is no trial transcript currently before this court on that oral hearing. So whether on the motion to dismiss or waiver of arguments, we would ask that this be dismissed as premature or that the appeal be denied at whole and the court not consider the constitutional issues. However, should the court decide to go on with constitutional issues, a statute is given a strong presumption of constitutionality. Our Supreme Court has stated that the standard is a part.
Counsel, if you don't care, before we get into that,
Sure.
go back a little bit
Yes.
to the jurisdiction of the court. So if the 41A1A dismissal is not a final appellate order, how does he contest the constitutionality of it?
After a final order is issued. If a final order, say, the matter was completely tried through, if the plaintiff prevails, the issue is moot, but the plaintiff has also come out victorious. If the plaintiff loses at trial, he may then preserve that issue on appeal. And if he is in fact correct that it was not a constitutional amendment, that would vacate the order of the trial, finding in favor of the defendant, and it would also allow the appellate courts to reinstate the dismissal. So he does have the option of seeking redress on the constitutionality of the amendment. He just has to go through the whole process because there is no substantial right to the dismissal since the amendment occurred.
What about a declaratory judgment?
None was filed in this particular
I
case.
understand, I'm just saying,
That would present an odd set of circumstances. However, it would be two separate actions. The action could move forward as the workers' compensation action, and then the DEC action would have to proceed separately.
thank you.
Thank you, Your Honor. Again, the constitutionality of a statute is strongly presumed. The Supreme Court has stated that a party challenging must prove beyond a reasonable doubt that a statute is unconstitutional. This means that there must be no set of circumstances under which the statute would be valid. Here, the plaintiff has not proven that. In fact, most plaintiff's argument is not pointed at what legitimate government purpose does the state have or not have. It's pointed at what prejudice might the employer suffer, but that's not the question under the Constitution. We look at whether the amendment to the statute is rationally related to a legitimate government purpose, and here it clearly is. The state has an interest in protecting the two parties, or the two primary parties at issue, the claimant and the employer. It does so by allowing the claimant to continue participating during the pendency of the employer's appeal, and it protects the employer by making that appeal occur expeditiously. Pre-amendment, it could take 3, 4, 5 years before an employer's appeal is heard. Now it generally occurs within 1 year. This is all ultimately for the benefit of the Bureau in the state of Ohio. The Bureau has an incredible interest in protecting the state insurance and the state surplus fund, because while the appeal is pending, the claimant is receiving medical and indemnity benefits from the state insurance fund, and if the employer prevails, the state insurance fund, the Bureau must reimburse out of the state surplus fund any costs or expenses because of the increased premiums to the employer. So the state could effectively get hit twice for the same claim. Now, plaintiffs argue that there is no prejudice or there is no effect during the pendency of an appeal. That is incorrect. Arthur Brass is old law. The amendment to which it referred has been twice amended. Even in Arthur Brass, the Supreme Court stated that while medical shouldn't be charged against an employer's risk account during the appeal, the indemnity or the disability payments were immediately chargeable. Now, under the new version of 4123-512H1, both medical and indemnity are immediately chargeable to an employer's risk account, which results in higher premiums. So there is prejudice. There is no equal protection violation here. Both employers and claimants are treated exactly the same. The party who filed the original notice of appeal to the court is the party that controls the right to file a dismissal. Plaintiff files a notice of appeal, they can dismiss at their own will. If the employer filed the notice of appeal, the employer may or may not consent to the plaintiff's dismissal. It treats the parties near equally. If anything, it is to the slight detriment of an employer who cannot himself force the plaintiff to dismiss. Plaintiff has shown in no way that there are any equal protection violations, and this is part of the failing of Ferguson. Ferguson relies upon this old law in Arthur Brass and relies upon this false concept that there's some difference between the way the amendment treats the claimant and the employers, and that's simply not true. plaintiff has also argued that there is a due process violation. But due process is simply the opportunity to be heard in a meaningful time and in a meaningful manner. This amendment doesn't deny that. The plaintiff still has the opportunity to be heard at trial. They must do so a little earlier than they might like. They might like that 3 years to participate in benefits at the detriment of the employer and at the detriment of the state. But now they can't do that. They must be diligent in preparing their case. And in this particular case, if you look at the record, the claimant had filed his medical expert deposition, had filed motions in limine, a trial brief. This matter was set for trial and ready to go in April of 2012. There was no harm or no denial of due process in this particular case. Plaintiff also argues in his brief that the plaintiff doesn't know the extent of his disabilities by being forced to go so early. But extent of disability is not an issue before the trial court. That is solely within the province of the Industrial Commission. The only issue before the trial court is whether or not the plaintiff received the alleged injuries in the course of and arising out of their employment. Plaintiff has yet again failed to prove any denial of due process or constitutional violation by the amendment to 512. Lastly is the separation of powers. As thoroughly outlined in our automation's brief, the General Assembly has significant authority to make determinations and limit the availability of certain remedies or certain rules to parties. 512 has long limited the availability of Rule 3, Rule 4, and Rule 4.1. Rule 3 deals with commencing an action by filing a notice of appeal, jurisdiction and venue issues, and issues regarding transfer. These have been challenged before, and they were upheld as constitutional by Moore versus Van Wert. So there is significant authority stating that the General Assembly may make such changes to the statute that affect the civil rules. Such an effect is contained within the rules themselves. Rule 1C7 states to the extent that the rules are non-applicable, they shall not apply in special statutory proceedings like workers' compensation matters.
To the extent that they are not applicable.
To the extent they would, by their nature, be clearly inapplicable, they shall not apply to procedure.
And is it the employer's argument that Rule 41 is not applicable to these proceedings?
That is correct, and that has been determined by the General Assembly, who has the broad authority to make that determination. And I think this becomes clear not only through the constitutionality of what 512 has done previously to Rule 3, Rule 4, Rule 1, but you have the Arrington case, which stated that the General Assembly may divest workers' compensation parties of the right to a trial by jury. It is a very broad authority that the General Assembly has, and that's because workers' compensation falls under Article 2, which is the sole power of the legislature. If you look at all this case law through the lens of the more recent post-amendment cases of Thornton and Bennett, Thornton states in paragraph 14, now an employer must consent to the dismissal. Thornton notes that while pre-amendment, while deciding Valley, that it noted the employer's frustrations in these actions. But instead of legislating from the bench, we let the General Assembly do what it wants with workers' compensation proceedings. And within a few months of Valley being decided, that's exactly what the General Assembly did. It amended the statute to foreclose plaintiff's ability to file a dismissal during an employer's appeal. And all of that is for a legitimate government purpose of protecting all the parties and the state insurance and state surplus funds. Even the dissent in paragraph 33 notes that the General Assembly has finally fixed this problematic procedural quagmire. The dissent, in fact, believes that this should not only be a prospective application, but it should have been retrospective. All the cases before the amendment arose should be foreclosed from plaintiffs. Now, that ultimately didn't prevail by the Supreme Court. And lastly, you, of course, have Chief Justice O'Connor's note in Bennett at footnote 3 stating post-amendment, Kaiser, Robinson, Fowley have been superseded by the amendments to the statute. Ferguson fails to utterly take into account either Thornton or Bennett or any of the broad discretion available to the General Assembly when fashioning remedies. In fact, the only reason the civil rules of procedure apply in 512 actions is because 512D, promulgated by the General Assembly, says so. So on behalf of Automation, I believe I'm probably at my time or near.
About 3 minutes.
Over?
No.
Oh, Sean, really? Well, if your honors have any questions, I'd be more than happy to address them. Otherwise, I thank you for your time, and on behalf of Automation, we would ask that you either dismiss this appeal or deny the appeal, affirm the trial court's order, and send it back for immediate trial. Thank you very much.
You have about 3 minutes remaining.
Thank you. I just want to quickly first address this issue of whether or not it's a final appealable order. Under Revised Code 2505.02, it's a final appealable order if it affects a substantive right. And in this particular case, there's case law that says 41A, since it's a civil rule, is a substantive right. The definition in 2505.02 indicates that the substantial right means that the United States Constitution, the Ohio Constitution, a statute, the common law, or a rule of procedure entitles a person to enforce or protect. So that is why this is a final appealable order.
So you do not agree with the employer that you could just address this issue should you not prevail at trial?
No, because the trial would have, he indicated the trial would have occurred already. And so, therefore, once the trial is done, why would we waste the time of having a trial? If we had the trial, then there's no reason to do a 41A. It doesn't make any sense. So then we have to retry the case all over again?
Well, as I understand the argument, maybe if you wanted to, if you had been harmed by the denial of your dismissal and you had to go forward with trial and then you won the argument that you should have been allowed to dismiss, I think the outcome of that argument is that you may get to retry the case.
I would, well, but the argument is that it would force the claimant to try a case when, for whatever his reasons were for line of 41A, okay, is going forward when the claimant wasn't ready to go forward. And now, once that trial has occurred, the issue on appeal of whether or not you could 41A becomes moot because the trial has occurred. And now you would have to, his scenario is that if ultimately the Court of Appeals were determined that the trial court was wrong in denying the 41A, then now the case goes back to the trial court to retry the same case all over again? That makes no procedural sense.
But it seems like maybe that's what the legislature is saying, and it may be a declaratory judgment to attack the constitutionality of the statute.
Well, I think you can attack it in different ways. And my feeling is that you can attack, by exercising what I believe to be the right of a 41A, and then the court striking that, and under case law that is clearly historically indicated that a 41A is a right, and therefore is a final appealable order, that creates the issue for this court and creates jurisdiction in this court and makes it right for an appeal. That is, my contention. I don't think I have to file a declaratory judgment action on this issue. I did in the McClellan case, but I don't think I have to in this particular case. I do want to also, one last thing, in one of the last arguments by the employer, he was arguing that he kind of did a circuitous argument about it's no longer a substantive right because 4123.512. And that's also their argument in this issue on whether or not it's right for appeal.
And counsel, you have reached the end of your rebuttal time. Thank you so much
All right,
for
thank
your
you.
arguments and presentations today. Thank you both sides.
Thank you.
The court will take the matter into advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.